Again, thank you.
Got it?
I'm sorry.
No.
Okay. Again, thank you everyone for being here. Welcome. Welcome this evening. My name is Dr. Laso Hall. I am the president of the NAACP New Bedford branch, and we're so excited that you're here for our candidates forum. Tonight's forum is meant to be a discussion from the NAACP and obviously from our members directly to each candidate here in the Bristol County DA race. The format is fairly simple. The candidates will be on one at a time. In this case, the incumbent is going first, Attorney Quinn. He will have 3 minutes to make an opening statement. From there, we will ask some questions. Then we'll take some questions from the members that'll be vetted. And then Attorney Quinn will have a chance to make a closing statement of 2 minutes. Tonight is meant to be informative and meant to learn from each candidate and learn a bit more. We are excited to have both candidates on this evening. It is very clear that the vision of the National Association for the Advancement of Colored People is to ensure a society in which all individuals have equal rights and there's no racial hatred or racial discrimination. To that end, our mission is very clear. Our mission is to ensure the political, educational, social, and economic equality of rights of all persons and eliminate racial hatred and racial discrimination. The NAACP is a nonpartisan organization. Therefore, we do not endorse any candidate or any political party. We are here to ensure and to discuss the policies, laws, and legislations that impact our members and our community. To that end, we're happy to have DA Quinn here with us this evening. Thomas M. Quinn III is the District Attorney of Bristol County, serving as Chief Prosecutor of all crimes that occur in the county's 20 cities and towns. He was appointed to the position by Governor Patrick and Bakers in 2015. His appointment received widespread support from the community, who cited his 25 years of experience in the justice system, including 8 years as First Assistant District Attorney, and his commitment to the community as a lifelong resident of Bristol County. Since his appointment in 2015, DA Quinn has been elected twice by the citizens of Bristol County. We're happy to have you this evening, DA Quinn. The floor is all yours.
Good evening, Dr. Hall. Thank you for the opportunity to address you tonight. As you indicated, I've been the district attorney for almost 8 years. I'm running for a 3rd term. I'm here because of the support of the citizens of Bristol County, which I'm forever grateful for. I have strong roots in the South Coast area. What happens in these communities is important to me. My family is from New Bedford. I grew up in Dartmouth. I graduated from Dartmouth High School. I currently live in Fall River. I've been there for 35 years, where I've raised my family. During my time as a prosecutor, I think at any level, I've tried to have a balanced approach to prosecution. I'm one of the few attorneys who has both prosecuted murder cases and defended them. I believe in fairness for all. Without that, the system does not have the credibility it needs. I'm very proud earlier this year to be the first district attorney, certainly one of the first ones to support the commutation of a man who was convicted of first-degree murder in New Bedford a number of years ago, over 30 years ago, and was going to serve the rest of his life in prison. His name was Thomas Kuntz, who's a Black man from Brockton, was in the Marine Corps. And I supported that commutation, difficult circumstances with family having lost someone, but I thought it was the right thing to do. And I think that's an indication of the approach that I've taken to the job. I've been about doing the job and trying to do the best I can in a fair way for the citizens of Bristol County. We've had a number of accomplishments that I'm proud of that our office has done. We've had a 95% homicide solve rate Since I've been the district attorney, approaching 8 years, homicides are down 20%. I've made a priority of protecting the community from violent criminals, people who are hurting innocent civilians like women, children, the elderly, innocent civilians. People have a right to feel safe in their communities. Also proud of the successful prosecutions of Aaron Hernandez and Michelle Carter, 2 high-profile cases. I'm very proud of creating an elder fraud unit to protect our seniors from fraud and abuse. Our seniors have given so much for our communities. They deserve to be protected. That's what I've done. Very proud of my office's rape kit initiative. We came to learn during the investigation of a New Bedford murder that a number of rape kits throughout the state, including over 1,100 in Bristol County, had not been fully tested. I was very frustrated, but did something about it. The only district attorney to apply for and obtain a grant to fully test all these kits. We're on track to do that by the end of the year. Again, over 1,100. We've solved several violent cold case rapes that go back to the city of New Bedford, 2010 and 2012. Also proud of our cold case unit that has solved several violent sexual assaults and also several homicides. We just identified a body in Fall River. It was left in a landfill almost 17 years ago. We look forward to continuing to put a lot of effort into those cases. We solved the case of a serial rapist using advanced technology in Bristol County last year. So I'm very proud of that. I've been about getting the job done, trying to be fair, again, protecting the public, but being fair to people who come before the court. And I, again, stand by my record that I've accomplished with a very effective staff and the support of the people in Bristol County during the past 7.5 years.
Thank you so much, Attorney Quinn. Greatly appreciate you. Now we will go ahead and ask some questions. You will have 2 minutes to respond to these questions. Let me know when you're ready.
Ready, sir.
Wonderful. The first question is around prosecutorial discretion. For lower level crimes, is prison the best option in light of the high cost per inmate and high recidivism rate? Would medical, counseling, and other diversion programs be a better use of resources and provide better results for the community?
Well, Dr. Hall, I think the answer is yes in some cases. I think it depends on the facts and circumstances of each case. I've had significant experience in the criminal justice system, approximately 35 years. As I said, I've been on both sides of it. I have given, in my career, I have given people a break, so to speak, in many cases who I feel weren't threats to the community and showed an ability or amenability to rehabilitation and being productive members of society. I certainly would get more satisfaction out of assisting someone without going to jail, move forward with their lives. I believe in redemption. But I think it just depends on the facts and circumstances of the case. Incarceration is not an issue in every case. In fact, most people aren't going to go to jail. Obviously, the focus is on the violent repeat offenders who are, hurting communities and victims. So I certainly am open to that, but it's and do that. But again, it depends on the facts and circumstances. You could have someone with, committing lower level crimes repeatedly. They may need a period of incarceration, but there can be a disposition crafted that can get them counseling or treatment. I think based on my experience, have a pretty good feel for whether someone should be incarcerated or not, based on my experience. I'll give you one example, Dr. Hall. We've initiated this program in New Bedford called the LEAD program. It's a law enforcement assisted diversion. It started on the West Coast. When the police arrest somebody for lower level offenses, some of which you're referencing to, the they are diverted if they comply and they agree to get treatment for lower level offenses. They are diverted prior to arraignment, so they would not even make it to the criminal justice system. To treatment, I think that program, despite COVID and the limitations of that, have successfully diverted over 130 people in New Bedford. The program is starting in Taunton. I had a case, we diverted someone, a woman who was pregnant with a child, who was under the, had been using, was able to, through the assistance of the program and getting treatment and not going through the court system, successfully deliver the child and wrote a very emotional letter. So I think I've been doing those things and will continue to do them. I think that, again, an example of how you would divert people even prior to getting into the system. And that's why I believe I have a balanced approach to prosecution.
Thank you. The next question falls under plea bargains.
Yes.
Many experts say prosecutors overcharging defendants, even when they have weak or insufficient evidence, unfairly pressures defendants into taking pleas. Would you pledge only to file charges that you are confident the evidence supports?
I've never been one, Dr. Hall, in my career to overcharge, as you say. I think the first determination is there probable cause to believe these charges are committed, and does the evidence sustain a conviction? If presented, sustain a conviction. So, I've never been a big fan of overcharging. I don't believe in the evidence is what controls in these cases. Can we prove it? So that's never been my philosophy, nor will it be. But sometimes the evidence might be weaker against one charge than the other. That doesn't mean it can't be brought. But I've never felt comfortable doing that, trying to bring all these serious charges and leverage them against somebody. I mean, the evidence may support it, may be strong in one case. In some of these cases, you have in some examples, sexual assaults of children, for example, very serious cases. You have strong evidence in one case, and maybe a stronger case. There is evidence there, but it may be up to a jury to see if it can be sustained. But I believe in fair play and fair treatment. I would certainly people who have a history of committing crimes, especially serious crimes, I'm going to be tough on, but I'm not a believer in overcharging to leverage a plea that maybe isn't fair. I believe in getting a result that is appropriate based on the circumstances of the case, a reasonable result. It's not in the cases that come before me.
Thank you. The next question will be dealing with the topic of bail. Do you favor changes at the state level to eliminate the use of monetary payment or cash bail as a condition of pretrial release?
Actually, Dr. Hall, the answer is yes to that. The issue of bail has always been very a big issue to me. I think it really comes down to, should the person be held or not prior to trial based on the facts and circumstances of the case and their record. So I'm actually have been advocating with the legislature to make changes to the dangerousness statute, when you can detain someone without bail because they're a danger to the community. And one of the main reasons for doing that is a less arbitrary approach to the question of bail. Which has been the setting of cash bail has been the traditional approach in the criminal justice system. The more serious the crime, often high cash bail will be set because the person would potentially be a flight risk and is facing a serious jail sentence. But in many cases, someone maybe didn't have the means to make the bail, would be held, where somebody, say, for example, people charged with drug dealing who have accumulated money as a result of drug dealing would post bail and get out. So I think the bail system needs to be reformed. It's actually the case law. The Supreme Judicial Court has said you cannot ask for a high cash bail just to hold somebody. As you referenced, you would need to move to detain them under the 58A statute. And that's what I've lobbied for, is to have some offenses added to that statute, like raping a child and other firearms offenses, because it's more equitable. We look at the facts and circumstances of the case. It doesn't really matter what your means are or not, or what anything about you is. The question is, you did these crimes, or you're accused of this. Do you remain a danger to the community, and should you be held in custody pending trial? I think it's a much fairer approach. I think it's a simpler approach. Regardless of your ethnicity or race, I'm looking, you've got a pending gun case, you've already been released, you're back in. Whatever the factors are, you're on probation, you're on parole, you have a significant record. That's what the focus should be on, not determining what some people could make. And then if somebody's held in bail for $1,000 because they can't make it, they may not be a flight risk. So I've been advocating that for a number of years, and I hope we can achieve that, because it's more equitable for everybody in the court system who is brought before the court and faces charges.
Attorney Quinn, I want to stay on that topic of dangerousness, and I want to give a little bit of information from what we've gathered. In the eyes of many experts, Massachusetts 58A, as you say, dangerousness provisions amount to the denial of bail. So Bristol County has among the highest percentage of so-called dangerous individuals who are not released from bail. And this even extends to children. Bristol County's percentage of dangerous children is twice the state average. And both the governor and the incumbent to lock up even more individuals as dangerous. Can you kind of talk a little bit more about that? You started a little earlier.
Yeah, well, again, I'd rather try to simplify this. It really comes down to, does the individual belong held in jail prior to trial or not, based on the facts and circumstances of their record in the case. I've taken, I would say, a purer and more equitable approach, which really is based on the law, Dr. Hall. The SJC case said you cannot ask for high cash bail that essentially is pretrial detention. And that's how it used to be. I want to hold you. It's the easiest thing to do. You're charged, you have a record, you're charged with a shooting, you're charged with drug trafficking, some sort, 25,000, or whatever the amount is, 50,000, 10,000. That's an arbitrary figure. It's designed in most cases, if judge said it and the DA asked for it, to hold the person in custody because they want them held prior to trial. My approach is different. It's looking at the case and saying, under the existing law, the dangerousness statute, you are a danger to the community. Many of these cases involve domestic violence. These were egregious cases. There's a woman who just got a case that just got convicted. It was yesterday or today in Superior Court, a domestic violence case. The woman had her face smashed in, broken orbital bones, cheekbones. That individual was held as a danger, was actually released and shouldn't have been, and then committed more violations. So those are the people that I'm focusing on to keep off the street. It's not a question of money. You take the money out of the equation, other than a few cases, and you focus on the record. I think it's more equitable. I can tell you in good faith, for someone who's been involved in the system for a number of years, there's not a lot of people held in custody, especially via dangerousness, that should not be held. In our case, I don't know the precise statistics, but juveniles, there are some very dangerous juveniles. And I'm not talking about minor offenses. Many of those people are diverted. We have pretrial juvenile diversion. I certainly am open to that. I made mistakes when I was young. I don't want to have that open. But you have violent individuals running around with firearms, shooting people. If the facts and circumstances warrant it, they may not belong on the street. And that's ultimately up to a judge. So I think frankly, Dr. Hall, that I am focusing really on adding a few crimes to the dangerousness statute so we can move on, like raping a child. I could be 40 years old and rape a 6-year-old child, and if they don't allege force, which how is a child at that age going to resist? They can't move to detain me. I could be a sexual predator. I could be a deviant with a horrendous criminal record, and the prosecution could not move to detain. No rational person thinks that's appropriate. Manslaughter, involuntary manslaughter. We just argued a case. individuals driving down the street, a pedestrian's on the street, a poor woman drives over, smashes and kills her, takes off. We just want the opportunity to add some offenses to see if those people should be held pending trial. So it's more equitable, it's fairer. I'm sensitive. I don't want to see anybody in jail who does not belong in jail. That's how I've operated for a number of years. We can have a disagreement maybe in certain cases whether someone should be held or not held, but it's a fairer and more equitable approach. And then if a judge feels that they're dangerous, but other conditions are sufficient, then that's the judge's decision. So many of our petitions are upheld, but it's moving away from this cash bail game, which was always meant to detain people, in many cases, poor people who couldn't afford bail. I'm against that. So what I'm proposing is, I think, a fairer approach. And it does not when they say they're going to make it easier to detain people, I'm focusing on two provisions, adding some offenses that I mentioned. And you have 1 year to bring somebody to trial, which is consistent with the rules of court that already exist. I think that's reasonable. That's my approach. I think it's a fair one. And it moves away from the cash bail system, which is antiquated, outdated, and arbitrary.
We're coming up on the last section here, and this topic is on the topic of race. And after that, we will open it up for 2 questions from the audience before we accept your final closing statement. So the final question here from the committee.
Yes.
A prosecutor's subconscious and unintentional attitudes about other people based on characteristics such as race often influence the outcome of a case. Will you commit to requiring prosecutors in your district to participate in implicit bias training to reduce the influence of these views in the prosecution of cases?
I certainly would have the staff participate in that, but I just want to tell you what I'm about as a prosecutor. I was raised to respect everybody. My father, who was a juvenile court judge, and uncle, who was a public defender, who defended many people of color. I had a very good example set. My father started the first Martin Luther King ceremony. I don't know if it's the first, but in the court system, starting in the late 70s, we brought in students and people from around the county. Late Dr. Herbert Waters from Kearney Academy would bring his class in, and he'd bring speakers in. There was some New England Patriots. I remember going to some of the ceremonies, some of the ceremonies myself. I think he had somebody who was involved in Alabama and the busing issue come in and speak. So that's what I was raised. If anybody, so we want to be cognizant of race. When I say have never, I view a person, we're all equal under the law in God's eye, and that's how we're treated. If it happens to be a person of color who's running around shooting people and carrying guns, they have to be detained to protect the community. Same should go as for a white person or any other race. So that has been my approach. I think we have to be vigilant, but it's not, Massachusetts is different than other parts of the country with respect to race and the court system. I mean, I've been involved a number of years. You have judges overseeing matters in court, prosecutors. So I'm certainly sensitive to the issue, but I have based my career on being fair to people, and I have not heard otherwise of how people have been treated. There was somebody coming up to me the other day on the street and just said, "Hey, I want to vote for you, support you in the election," but it was somebody I had prosecuted. I said, "Well, you go register to vote," but I've tried to be fair and balanced, and certainly the race of people is a factor, but I treat people equally under the law. We're all equal.
Okay, thank you. At this time, I will allow for 2 questions to come from the audience. I ask that you keep your questions brief to allow DA Quinn to respond, and also keep us on our time track as we have to welcome our next guest. So at this time, you can raise your hand. I see a question from Vice President Ledbetter. The floor is yours.
Good evening, District
evening.
Attorney Quinn. I was just wondering, do you have any initiatives in your department that help with prevention? And it's a kind of a two-part question. And have you ever looked at the Oregon? They have like a college campus for youth, and it's a pretty cool program. But I'm just wondering if you have any strategies for prevention, intervention, because I did see a comment about 12 to 17-year-olds being most in prison.
Yeah,
So do you have?
I'm sorry, go ahead. Yeah, I'm not
Nope.
aware of those statistics. I've never heard of that before. I mean, I don't think that there's not many 12-year-olds or 13 in custody, but with respect to prevention, I've been very active in the community with substance abuse issues. We have diversion. I mentioned in the lead diversion, pretrial diversion of people in New Bedford, 134 people. We have juvenile diversion, where juveniles are diverted prior to arraignment to address these issues. Obviously, they're not serious public safety issues because diversion isn't appropriate. We've partnered with a group in Taunton, Corey's Cause, for an individual who almost died from an overdose, who goes out to the schools and speaks in a very effective way. And I'm looking forward to re-engaging with that because of COVID. People, for the most part, have not been allowed into the schools. We've started the Bristol Alliance. I partnered with South Coast Hospitals to form a county-wide group of people to deal with the opioid issues relating to the substance abuse. We just met, had our conference started again last month, or I believe in June now. I mean, I don't really have enough time to talk about the initiatives. I'm sensitive to at-risk youth. I serve on a board of a school. People don't come from the ideal circumstances. So I've tried to initiate funding in that to assist in that area. We've had this hidden in plain sight. This is related to substance abuse. We set up this mock bedroom display. We've gone to the malls, to some schools. Again, pre-COVID, where people, the parents can see how children can hide their drugs, conceal them in a bedroom setting. We've had a teen safety summit every year, excluding COVID, that we reinstituted this year. That brings teens together throughout the community, talk about issues that face them. I'm concerned for their safety, the decisions they have to make, especially with social media. In fact, one of the speakers was from the Parkland School in Florida, where there was the tragic killing several years ago. I think it was on Valentine's Day. So a girl in the school spoke about what was going on, and her mother, the phone call out and in. So I think we have a number of preventative measures that I have funded, and we'll continue to do so. Again, that's the balanced approach I want to have, is try to be helpful in the community. It's not children for youth, but elderly. I've already mentioned that. I go to every senior center in the county multiple times to talk about prevention, because our seniors are being scammed significantly. I care, concerned about them. We had an elder summit this year. There were like almost 500 people there from New Bedford, from all over the county, talking about prevention, that I care about you, and that we're doing things. I've created a unit and I've staffed it, but prevention is key. So I will continue to work on those efforts in the community.
And I know our time is short, but we will take one more question from the community before closing statement. Please raise your hand. Richard Larry, the floor is yours.
Yeah, hi, DA Quinn.
Good
For
evening.
a number of years, I'd say the last 2 years, the number of nuisance calls, spam calls, has been really minimal, which is great. But over the last month, there's really been an uptick. And recently, like over the last 2 weeks, I've been getting on the order of 5 to 8 of these spam phone calls a day. Quite often, there's someone selling solar panels or this, that, and the other. And it's quite annoying, and it's quite intrusive. And a lot of times these people use a phony name to when they call. And I'm just wondering, is there something that the DA's office can do about that?
I don't know about blocking the calls because I've been out now to the senior center, especially recently, and that issue has been raised. I've gotten a number of spam calls myself daily, like you said, 5, 6, or 7. I think the technology is such that these people are calling. Some of the residents there talked about how they effectively block the calls. Unfortunately, these people are making thousands of calls a day. And with the technology, it just makes it very difficult to stop them from calling. But it's very frustrating. My advice to seniors, that's not directly your call. I don't answer the phone. You should not answer the phone unless you know who's calling. If anybody wants to call, they'll leave a message. But it's really become a plague on the technology. So what we're trying to do, though, is just advise people not to engage with individuals either on it's not just the phone, it's the computer. Our seniors sometimes are bundled because they're home. And it's not just seniors, it's everybody else. I got a call about Medicare the other day. They don't call over the phone. So I foolishly answered it because I have, it was on you don't know if it's occasionally somebody's calling, it might be business that the number's not programmed. So I'm getting a call about Medicare. They're not asking me, they don't call over the phone. So I think it's difficult. You could maybe devise ways to block the numbers, but these people are slick and conniving, and you're getting them all the time. But that's what I've tried to do is encourage people not to answer the phone. If you answer the phone and you don't know the person, you got to hang up right away. There's legions of stories of people have been scammed by getting engaged with these people, and all of a sudden they're threatening them that it's the IRS or a romance scam. And this is coming firsthand from the people who were victims of that. And then again, this incessant calls from people. So it's unfortunate, but I appreciate the question. I just don't know if there's nothing we can do to stop the calls. It's really, I wish we could go back to the landline days. And I've said that to the seniors, it just make life much simpler. It wasn't the end of the world then. It's just constant with these phones, whether it's text messages. I'm getting text messages. I'm getting now, hi, how are you? I just got one today. So I delete it. That's a scam. They're going to engage me, and then I might give them some information. I remember calling my own father, just to wrap it up. He claimed he got, this is a few years ago, said, I've got the IRS called. Oh no. So I said, well, look at this, what you say. When they call up, the IRS does not call by phone. So I called up myself, pretending to be the IRS. And he did give the answer and hung up. So that was good, but it's very tough to stop the calls. So, but we're trying to just encourage people from, discourage them from answering the phone. They don't know who's calling.
Thank you, Attorney Quinn. We'll ask that you do your closing statements. Please keep to 2 minutes as our next candidate is awaiting. Thank you.
Okay. I stand for re-election. It's been a pleasure to serve the people of Bristol County. I've been about doing the job and getting results for the people of Bristol County. I've had a balanced approach to prosecution. I have not had people say throughout my career that I've been unfair. My opponent, who is challenging me, certainly has every right to challenge me, but I would just keep in mind what the clear reason for her running is. She had to leave, she resigned or was going to be terminated because she was arrested for assaulting her husband and was engaged in very disturbing conduct. People make mistakes, but in this particular case, drunk, trying to frame the husband for assaulting her, not cooperating with the police, making misstatements to the police, shows that she's not fit to be the DA. No experience, and has made nothing but inaccurate and false statements about me during the campaign. She in fact told a local reporter, this is on record, not from me, that the reason she's running against me is for retaliation and revenge, because she had to resign or was going to be terminated. There is no substance. Again, I stand on my record, and I just want to point that out to keep in context for the things that have been said and just misrepresented. So But I've been about doing the job. I'm here to serve the people. I don't have any other agenda about trying to be fair and balanced. It's a difficult job. You got to make a lot of decisions that are coming in, again, to balance public safety, victims' rights with the defendant's rights. I've been on both sides of the cases. I have a record to speak for it. We're fighting cold cases, as I mentioned, reviewing them so families know we haven't given up on the cases, protecting seniors, protecting the public, but also bringing a balanced approach to prosecution. I have the experience to do the job. I've demonstrated that I can do it in a fair and balanced way. And I look forward to continue to serve the citizens because that's my only agenda, to do the best job I can for the citizens of Bristol County.
Thank you, Attorney Quinn. Thank you for your time.
Thank
and
you.
Have a wonderful evening.
Thank you.
We will now just waiting for Hi, thank you so much for being here, Attorney McMahon. Wonderful. Thank you again for your time. We truly appreciate it. Thank you for agreeing to come to our candidates forum this evening.
Oh, thank you very, very much for having me. This is amazing. I'm truly honored.
Absolutely. We are happy to have Attorney McMahon with us this evening. The format, it will be somewhat similar in that you are allowed to have 3 minutes for your opening statement. You will have questions from me as the moderator. Then we'll open it up to 2 questions from the community. And then you will have 2 minutes to do a closing statement. And just for transparency, I did place you in the waiting room because the candidate went over a little bit before, and the candidate has also left. So the floor is all yours. Thank you for your time.
Thank you very much. And again, thank you everyone for inviting me here today. This is an enormous honor to be invited by all of you, and to all the listeners out there. It's an enormous honor, and I thank you for your patience and for hearing what I have to say. My name is Shannon McMahon. I am the candidate for District Attorney from Bristol County. I'm very happy to be here tonight to share with you not only the reasons why I should be the next Bristol County PA, but more importantly, why Tom Quinn should not. Unlike my opponent, I'm not here because I inherited the title, both from birth and from the former district attorney. I'm here because I've worked very, very hard to earn my credentials and the experience to run for the job, a job which has been a lifelong dream of mine. You should be made aware that my opponent has refused to openly debate with me here tonight, agreeing to grace you with his presence only if I was not allowed in the same place at the same time as him. And this is just another one of his examples of failing his constituents. He failed to allow you to compare and contrast our answers, demeanor, our poise, all when faced with confrontation. In fact, Tom Quinn has failed us for years, failing comfortably in the top job, unchallenged since he was awarded this position. He failed to know that over 1,100 untested rape kits were in his care and custody and only miraculously appeared during an election year. He failed to disclose the very important fact that he has a close personal relationship with one of the 2 police officers involved in the Anthony Hardin shooting, yet he investigated it anyway. He has failed to disclose, after numerous public records requests, the Brady Cop list in this jurisdiction. He failed to pursue, even at the pleading of the police chief, the matter of missing and mishandled drugs and drug logs at the Fall River Police Department. He continues to fail to be transparent when he touts a greater than 90% solve rate. It is the police that solve crimes, not the district attorney. He has failed to sign the promise of other prosecutors across the nation, both red and blue alike, to not prosecute or extradite women seeking abortions or those providers who perform them. He continues to fail to answer the question, where does he stand on women's reproductive rights? Here's what I want you to take away from tonight. I am running on a platform of equal and fair justice for all, and I mean all. I am pro-choice, as I have said all along. My plans are to implement specialty courts for mental health for our veterans who have served our country. And I'm going to fix the recovery court that was once a great court. I'll restructure the victim witness advocate program because they are our first line of defense and they need some help. I'm going to aggressively prosecute the heroin, methamphetamine, fentanyl dealers because they're killing our citizens and they're killing our children. The only way to do that is to get users help and treat the dealers as dealers, unlike my opponent who treats them both the same. I will never be anything less than transparent. My opponent likes to continuously talk about an instance with my husband and I. Yet another failure on him to be transparent. My husband had to, unfortunately, release a press statement about that instance. He was recently diagnosed with brain cancer. He had just had brain surgery and he was on very, very heavy medication. I was the victim in that instance, and Tom Quinn knew it. The following day, he received my medical records showing that I had to have x-rays of my rib, my neck, my jaw, and my face. And he's used this trauma to embarrass me, to embarrass my family, for his political gain. At the end of the day, your chief prosecutor, your district attorney, should be the minister of justice. It shouldn't be about self-gain. It should be about what's equal and fair and just. That requires character. Look at the first time anyone dared question him. I ran against him. That's what I did. I've never made a single comment about family or his personal life throughout this campaign. I'm very proud of the campaign that we've run. We've run a very clean campaign, regardless of the slander that he has spewed about me. We have still maintained integrity, and I plan on continuing that if you give me the option as being your next Bristol County District Attorney. And with that, I am very excited to hear your questions.
Thank you so much for your opening statement, and I actually owe you an apology. I did not get a chance to read your bio, but I want to read it now because I want to be fair, and you certainly earned that.
Thank you.
Shannon McMahon is running for candidate district attorney in Bristol County. She's a lifelong resident of Bristol County, growing up in Swansea, where she currently resides. She's married to her husband, Brian, and together they have 4 children. She received her undergraduate degree from Roger Williams University and later on a law degree from the University of Massachusetts Law School, where she graduated top of her class. She considers herself to be a self-made person, having worked her way through law school as a judicial clerk, a student teacher at UMass Law, and a bartender. While raising 2 children, it wasn't easy, but she fought through it with hard work. She values earning success versus being handed. She has over 15 years of courtroom experience, first as a judicial clerk in the Superior Court, and then later as a prosecutor, assistant district attorney, defense attorney, and civil litigator. We'll get to our questions.
Thank you.
First question, this topic is around race. Studies show racial disparities in drug law enforcement. Despite the fact that white people and people of color use and sell drugs at the same rate, what would you do to minimize these disparities?
So obviously one of the things that I want to do, and I mentioned this in my opening, is we have to stop treating users like criminals, period, no matter what color. Users need help. It is the only way to fix a systemic problem. We know that. We absolutely know it for a fact. I was lucky enough to be one of the prosecutors, or the only prosecutor in New Bedford, who ran the, back then it was called the drug court, now it's called the recovery court. We were the very first certified drug court in Massachusetts. We had a huge success rate, and it was based on science. So the science basically says that users who graduate from drug court or recovery court, who actually graduate, are 70% less likely to commit another crime for at least 14 years. We know this. This is statistical. It's an absolute certainty. My opponent wants to treat users and dealers the same. We've got to take that away. We've got to use the courts to prevent crimes. They're not only used to punish. My opponent likes to say that's not his job. His job is to prosecute. It's not. And I'm quite frankly sick and tired of hearing elected officials continuously say it's not my job. Then whose job is it? I believe it's our job. I believe it should be our job. I believe when there's an answer right in front of us, we should listen to it. Another reason why I wanted to hire a full-time grant writer, which my opponent has failed to do, so we can continuously look at new ideas, at fresh ideas, to talk to other jurisdictions, see what they're trying, see what they're not trying. We've got real problems on our hands. Racial inequality over the drugs is one of them for absolute certainty. But we've got this global issue right now where we have far too many drugs on the streets. Our children are starting to use, we've got fentanyl laced in marijuana. We've got major problems. We really have to get ahead of this right now, and we've got to admit that there's a problem. The first step in fixing a problem is identifying that there is one. I'm willing to say there's a problem, and I'm willing to listen and do the research and hire people to do the research to see how we can fix that problem.
Thank you so much. I appreciate that. The next topic question is on police. What should characterize a relationship between the DA's office and local police agencies, court, and probation officers? What should that relationship?
What should it be or what it is?
What the question is? What?
So, I think I've said this story a few times. The DA's office is very, very closely aligned with the police department. They just are. We work together all the time. I knew when I was in New Bedford, I knew my police officers' spouses. I knew what they did. I knew what their children played for sports. There is a very, very close relationship. When I got married in New Bedford District Court, the entire probation department came. All the clerks came. You work together in a very, very stressful, high-intensity environment. Of course, you're going to be close. This is why I consistently say, if ever there is a time when I would have to investigate one of my police officers, I would hire an outside independent investigator to do that. You can't do it. You can't have it both ways. You can't have the relationship that's required to do the job and be able to investigate them. You've got to hire an outside investigator. I mean, take, for example, the Anthony Hardin shooting. So Attorney Quinn failed to disclose that one of the police officers was a very close personal family friend. I don't know what happened in that room. Neither do any of you. What I do know is the family of Anthony Hardin is destroyed because they feel that the DA covered something up. The two police officers who were involved in the shooting are also destroyed. The only person who wins when you fail to disclose conflicts of interest is the person who's failing to disclose it. He ruined those police officers and he ruined that family because he failed to say, I can't investigate it. And if you hear the way my opponent speaks, there is a sense of arrogance that comes across, meaning he believes that if he has to recuse himself, it's a sign of weakness. I believe it's a sign of strength. I think it shows that you support your police and you support your community and you're willing to not be front and center and be the spotlight so that the equal and just fair decision happens.
Thank you so much. The next topic is juveniles. What would your policy be regarding charging children in adult court, when would you use your authority to file charges in adult court? And when would you pursue a case in juvenile court?
So, I'm raising 4 kids, and I can tell you the world has changed since COVID. It's no longer, the kids are not doing well. I had a conversation with the psychiatrist, the head psychiatrist at Boston Children's Hospital, and they basically said that COVID acted like a microwave for adolescent children who would have eventually exhibited signs of mental health issues in their late teens, 1920s. COVID acted like a microwave. So now we have 13, 14, 15-year-olds suffering with mental health disorders, and the high schools and the junior high schools aren't equipped for it, because normally people don't start exhibiting those symptoms until they're in college, which is why colleges have such great mental health facilities on campus. High schools and junior high schools are not equipped for this. There is not a single bed to be had for a 13 to 17-year-old child right now who actively tries to kill themselves. It's about a 3-month waiting list. If anybody here knows a 15 to 16-year-old, we can probably all safely agree that they're not going to want to stay at St. Anne's in the ER for 3 months waiting for a bed. We have a real problem with our juveniles right now. To be perfectly honest, I don't know the answer to your question. It would absolutely have to be on a case-by-case basis, taking into account that there is just no help for these kids right now. The dropout rate is going through the roof, and we've got to do something. I've spoken to Maura Healy about this. I've inquired as to whether or not we could maybe incentivize UMass Law, UMass Amherst, to get people into the mental health field right now, like we did when we needed teachers in the inner cities. We've had that conversation, but we've really got to do something. These kids are suffering, they're in pain. When we have adolescents who are exhibiting symptoms of bipolar, schizophrenia without medication, it's a very, very short step to self-medication. And it's an even closer step to committing a crime. If we get a juvenile in juvenile court who has committed a crime, and it's the first time, I think it is of the utmost importance that we look at all of it. We don't just look at a police report. We look at where this child came from, what is going on in their life, what has happened. We should screen them. We should have a clinician in juvenile court to help us with this. These are things we need to do, because too many times I've seen in the current administration, kids go to juvenile court, they're arraigned, they have to write a book report, and that's the end of it. We have so many opportunities to use this court to get people the aid they need. And we can do that through grants if we had a grant writer, but we don't. So they have to write a book report. That doesn't help.
Thank you. The next topic is immigration. As DA, what would you do to develop a trusting relationship with the immigrant community in Bristol County?
So, I think one thing is basically not really talking ICE. ICE for years used to hang out outside of the district court. I don't think that's right. I don't think that the DA's office should be calling ICE. This is about equal and fair justice. In my opinion, if somebody comes into the district court for an arraignment, they should deal with that here. If it's a nonviolent crime and we can get that person help or create a situation where it doesn't happen again, great. If it is a situation where jail is required, great. But that should be the end of it.
Thank you. And this is the last question for me as the moderator. A majority of people in Bristol County jails are being held pre-trial. What steps would you take to safely reduce the rate of pre-trial incarceration in Bristol County?
Well, you know, we in Bristol County, we have the most, I think it's the most in the state that is asked for a dangerousness hearing. You know, the current administration asks for it pretty much in every single case that they possibly can. I was a judicial clerk for many years in Superior Court, and one thing I can tell you is that nobody likes the boy that cried wolf. It's dangerous. It's dangerous to do because the dangerousness statute can be very useful, and there are people that need to be held. There are many. There aren't as many as they're asking for. And when you have young ADAs asking for dangerousness hearing because the title of the crime meets a certain criteria, without doing any investigation, without talking to the families, without talking to, you know, if it's a domestic case, without talking to the victim, if you do all of those things, judges stop believing you. And then when you really need it, they're not going to know when you're asking for it for real. I do believe the dangerousness statute should be expanded, but I think it should be used so much more sparingly. We're talking about taking away people's rights. This should be a dead last resort. It shouldn't be the first. We have a bail statute, which the SJC, rightfully so, did change a few years ago so that bail can no longer be used to hold. It should be used to ensure the appearance at the next court date. Since then, judges have strictly enforced that. So bail can be used, but it's got to be within the means of the individual person. It can't be used just to hold them. My opponent believes that pretty much everybody should be held. And he likes having the highest number of detainees from the dangerousness hearing. And, you know, he was working on the dangerousness legislation. And again, I'll be frank, I do agree with expanding it to include predators, you know, child rapists. However, when you're talking about taking away someone's constitutional rights, if they need more time to analyze that, to say this person is really a danger to the community, or is it a one-time deal that's never going to happen again, then we have to give them that opportunity to investigate that. But yes, I think that we need to expand the dangerousness statute, but we also need to use it less in order to prevent more people from being pretrial detained.
Thank you so much. At this time, we'll allow for 2 questions from the audience. You can raise your physical hand if I can see you, or your virtual hand. Again, taking questions from the audience. Okay. If there are none from the audience, then at this time, Attorney McMahon, we allow for your closing statements.
Thank you. So I got into this race because I know that Bristol County can do better. We can do better at keeping our neighborhoods safer. We can do better advocating for witnesses and victims. We can reduce recidivism with specialty courts, and we can do better with securing grant dollars for the people of Bristol County, not for the people who work at the DA's office. My opponent has enjoyed 8 years of unopposed complacency. He has failed to be transparent in very important matters, such as several police shootings, over 1,100 untested rape kits languishing in his office for 12 years and surfacing during an election year when he was opposed for the first time, and this unicorn of a greater than 90% solve rate. Additionally, he's also talked frequently about the DNA initiative that he has done. And speaking of transparency, you should know that the Forensic Science Oversight Board did conduct a study and a report on the Bristol County District Attorney's DNA database, and they concluded that it was an unregulated database, and that it jeopardized the integrity and the reliability of forensic science in the Commonwealth. I have a problem with anyone who brags about something that is so clearly admonished within the field. Factually, it's the police who solve crimes, it's the district attorneys who prosecute them. So it's also unfair and not transparent to claim credit when police arrest people. Just so you all know, my opponent's conviction rate for all trials in Superior Court this past year is 46%. That's not transparent. As your district attorney, I will work every day to keep our neighborhood safer, to aggressively prosecute the drug traffickers who are killing our citizens and our children, to continue the wonderful work with our senior population, and to always use an independent outside investigator if ever there is even a hint of a conflict of interest. You will never have to wonder what I haven't disclosed. This is a Democratic primary with no Republican challenger, which means whoever wins on September 6th will be your next district attorney. As you prepare to vote on September 6th, I urge you to ask yourself, do you feel safer today than you did 8 years ago? Because I do not. And the voters who I've spoken to do not. And if you do not, then it is imperative that you vote for me on September 6th. We have to try something else. I am unbelievably grateful and very humbled by the invitation that you've given me today. And like I said, if anyone has any follow-up questions, please email me, phone call, anything you need. I'm here. My job is to listen to what is affecting Bristol County, and I'd like to hear from you guys.
Thank you so much, Attorney McMahon. Thank you for being here.
Thank
You have a
you.
wonderful evening.
Thank you very much.
And everyone, thank you for your time tonight. Thank you for attending our candidates forum. As stated early, we implore you to go out and vote on September the 6th. Thank you for your continued support of the National Association for the Advancement of Colored People New Bedford branch. Have a good evening.